Well, hello, everyone. Welcome to U.S. Accessibility Laws, What You Need to Know to Protect Your Business. I'm Sharon Spencer with IAAP, and before we start today's webinar, I just want to quickly review a few system things with you. Everyone should be logged into Adobe Connect, or you can follow along with the presentation provided and over the phone. To access the presentation, there is a handout link in the confirmation email you received when you registered or in the reminder email that was sent out a few days ago. And during the webinar today, if you want to ask questions, our speaker does plan to stop for questions throughout and at the end. If you have a question, you can type it into the chat area of Adobe Connect. If you have a problem accessing the chat area, you can unmute your phone and ask the question over the phone, or you can email your question to webinars@accessibilityassociation.org. And to unmute your phone line, you just press #6. And then *6 puts your phone back on mute. To guard against background noise, I have put everyone on mute. If there's time at the end of the webinar and you have a question you want to ask over the phone or through your microphone, you'll be able to unmute your line then, or you can put a message in the chat if you want us to unmute your microphone. And if you are hearing the audio over both your computer speakers and the phone, you have two choices. You can hang up the phone and listen via computer only, or you can turn off your computer speakers and listen via phone only. There is a full screen option to see the presentation better. Selecting that puts you in full screen mode, and then selecting it again takes you out of full screen mode so that you can access the chat area. You can access full screen through the icon, or you have an options list and full screen should be listed there. And lastly, I want to remind everybody that we will be recording this webinar. So again, I want to thank you all for joining us today for U.S. Accessibility Laws, What You Need to Know to Protect Your Business. Our speaker is Ken Nakata. Ken is the director of the Accessibility Consulting Practice at Cripzone and a well-known attorney in the area of IT accessibility. His work focuses on web and software accessibility from both a legal and technical perspective. Ken also worked for 12 years as a senior trial attorney with the U.S. Department of Justice. So we are delighted to have Ken Nakata with us as today's speaker. So Ken, thank you for doing this webinar for us, and I'll turn things over to you.
Okay, thanks Sharon, and good morning or good afternoon to everyone. As Sharon said, my name is Ken Nakata, and I'm the director of the Accessibility Consulting Practice at Cripzone. One of our lines of business focuses in on accessibility, both from an automated perspective as well as a consulting and kind of manual testing perspective. And we also do a lot of other unusual accessibility projects for some big clients that are kind of unusual in our space. Before we get going, though, I'd like to start with some poll questions to get some sense as to what the audience composition is like. So Sharon, could we go to the first poll question? So the first question is, what best describes the business sector that you represent? And here you can just put in, select your answer. So the answers are public sector, private sector, academia, NGOs, which is non-governmental organizations, or none of the above. And so far, it looks like private sector is winning by about 77%. A little higher now. Oh, wow, now they're up to 90%. And 10% are none of the above. So let's see. Okay, so it looks like private sector, it seems to have settled down now. So private sector is about 91%. And none of the above is at about 9%. Okay, can we go to the second question, Sharon? So the second question is, what best describes the functional type of work that you do within your organization? First one is executive leadership. So there we're talking about like CEO or board members and things like that. The second is legal or policy. Third is a product or business team. And fourth, the next one is technical, which is developers or testers, things like that. So right now it's, yep, we could have predicted this. So far it looks like the product or business team seems to be winning with about 37%. Legal policy is about 20, legal or policy is 25%. Nope, down to 22% now. Oh, let's see. Why don't we say, yeah, okay, well, I'm assuming that the results are pretty much settled in now. So now product or business team is at 55%. Behind that is other, which at 22%. And technical and legal policy wonks are both even at about 11.1%. So, yeah, that makes sense. Often, I was expecting in this kind of webinar that we would be getting people that were trying to actually implement accessibility, but it might not be this very senior leadership in the organization. So, okay, let's get back to our presentation then. It takes a little while from the poll to go to the PowerPoint presentations. So, today we're talking about accessibility laws and what you need to protect your business. Really, it's, let me give you an overview. It's really intended as a beginner-level presentation. And in large measure, the presentation was originally geared towards businesses that are confronting the threat of what I call drive-by web litigation. It basically means that plaintiffs' lawyers have figured out in this country that an easy way of making some money is to file web accessibility complaints. And well, the way in which you start is with a demand letter from the plaintiff, and then it's usually negotiated and settled well short of litigation. Occasionally they end up in litigation, but 95 to 99% of them just get settled very early on. And we've seen literally thousands of these around the country. So that brought a lot of people into web accessibility that otherwise didn't know that much about web accessibility. So that was the original genesis of the presentation, really just as a key introduction, And to do this, to try and create this analysis and to really understand web accessibility, I thought it would be helpful to break it down step by step. So first, we're going to introduce the accessibility laws. And here we're going to really focus on the Americans with Disabilities Act, Title III, and the California's Unruh Act. It really does focus mostly on private business and private sector accessibility, so we're not going to be touching on Section 504 or Title II of the ADA very much. We may just briefly brush on those things, but if you have questions about those laws, certainly feel free to ask them during the break section. So once we get a basic understanding of accessibility laws, the second question becomes, okay, how do you take those legal concepts, which predate the web, and apply them to the web? And it gets a little tricky there. So understanding that will help us understand some of the legal nuances and why, for instance, it's easier to sue in one part of the country than in another. Third, as we transition towards some more practical steps, the question becomes, well, what is this thing called web accessibility? How difficult is it to do? What do I have to know? Obviously, we're not going to go very deep in this because, well, one, it's a legal presentation, but second, it's also a very deep presentation if we wanted to talk about web accessibility. Just talking about WCAG and web accessibility could easily take at least a day. And lastly, I want to turn to, I think, the most important part of the presentation very briefly, which is summarizing what we know and trying to come up with some practical tips for achieving web accessibility and reducing your liability. So as we go through today's presentation, each of those topics is pretty well divided. And so it makes sense to take breaks between each of those sections. And so at the end of each of these different topics, we'll have a slide will come up, and we'll field questions on then. In the meantime, we'll just keep going through because we've got a lot of ground to cover. So, a little background on accessibility. A relatively high proportion of people have disabilities in this country. In fact, 1 in 5 people in the United States has a disability. In addition, there's significant numbers in terms of visual impairments. 1 in 12 have significant visual impairments. Also, in terms of hearing loss, there's a good number of people with hearing loss, obviously, but the number is varied, obviously, depending upon age group. This is true for any disability, really, but I think it's particularly true for hearing loss, where we start off with only 2% of the population between, say, 45 to 54, which is, upper end or middle end of working age Americans. And it starts to slowly creep up, 8.5% when you get to 55 to 64, then 25% when you get to 65 to 74. And then when you get to 75 or above, then it's 50% of the population, so a significant portion of the population. That trend is not just, obviously, a hearing loss. It's also other populations as well. And it's partially related to aging, significantly so, actually, I should say. But there are other factors, too. Our population is, just in general, even if you put aside aging, increasing, and the proportion of people with disabilities is increasing. For instance, one of the factors is the number of children with disabilities. And, for instance, autism is significantly on the rise. Other factors are things like the number of disabled soldiers that we have that end up losing some level of functionality when they, because of their service, and that's now accounting for a greater portion of the population. So, getting back to this aging phenomenon, though, our population is getting significantly older. In fact, every major industrialized nation is facing this phenomenon. Italy and Japan lead the way in that, and by the time that 2040 rolls around, about 50% of their population is going to be 65 or above. So it's a significant portion of the population is going to be older, and with that also increases the number of disabilities. So medical technology isn't keeping pace for disabilities as much as it's keeping pace for longevity. So medical technology, as it advances, enables people to live longer, but it's not enabling those people who are living longer to avoid the disabilities that tend to come with older age. So in a typical population, for instance, when you're, say, 18 to 25, the proportion of people with disabilities may be fairly low. It may be only down, say, in the 10 to 15% range. But as you get much older, 65 to 70, then the proportion of people with disabilities is significantly higher, more on the order of 40 to 50%. So most of us, because of medical technology, are going to end up living longer than that. And while that's a great thing, that also means that a significant number of us are going to have disabilities. So in addition to just helping people with disabilities, though, accessibility features that we put into products really does help everyone. We can think about examples like captioning on sports TV events when we're at a sports bar and it's really loud and we're trying to keep up with our favorite football team. Or when we think about things like speech output that's built into GPS, which a lot of us rely on every day for getting from one point to another while we're driving our cars. All of those technologies are a result of people researching accessibility for people with disabilities. So a number of years ago, Microsoft was interested in that phenomenon, and so they commissioned the Forrester Research Group to look into how accessibility features affect mainstream people. We're not focusing here on just people with disabilities. We're focusing here on the general population. So this includes people with disabilities, but it basically means, picking random people off the street and asking them, well, how do these different features of accessibility impact your usability of something like a website or a GPS or another piece of technology in a general kind of way. And what they found was that, I seem to have hit the wrong button. Help? There we go. Sorry. It's coming back. There we go. So what they found was something shocking, actually, that 60% of working age adults between the ages of 18 to 64 are likely or very likely to benefit from the use of accessible technologies in one form or another. So what we're focusing on in terms of helping people with disabilities actually improves usability for everyone. So those are some of the practical reasons. Focusing now on more of the civil rights angle and web accessibility, it's important to remember that the stuff we're talking about, web accessibility and the internet, is a fairly recent thing, a recent phenomenon, but it's become such an important part of digital citizenship in this modern age that it's critical to make sure that technology, the web, is accessible in order to participate meaningfully in our society. So, if you don't make your website accessible, it has the effect of potentially excluding an entire class of people with disabilities. So for instance, if you don't provide alt attributes in your images, or if you don't put labels on if you don't label your forms correctly, it basically makes it impossible for people in certain classes of disabilities to access your services. The problem, the unfortunate thing, is that addressing most of the problems in web accessibility are relatively easy. A lot easier than, say, if you're a business ripping out a set of stairs and putting in a ramp to your front door. In most cases, it's a lot less expensive to make your website accessible. The techniques are very well understood. WCAG 2.0 has been around for years. For the people who work in the field, it's a very well understood technology. And it's not just in the United States that this is happening. Web accessibility is a critical element to digital citizenship around the world. And as I look out at other countries and the things that they're doing, it's amazing just how fast all this stuff is happening. Just recently, for instance, in October, just a couple of months ago, the EU passed their new web directive. And that's basically what it requires is that it requires member states, basically every country in Europe that's part of the EU is a member state. It requires all the member states to develop web accessibility policies for their public sector websites. And so in one fell swoop, we've now flipped the switch on every government in Europe, well, every government in the EU, having to suddenly make their websites accessible. The same thing has been happening in Asia, for instance. Korea did this. Japan is going that way. New Zealand was first out of the gate to do this. Australia went this way. Every country in the world is going this way. And most recently, the United States is going this way with the new Section 508 regulations for the federal government, although the regulations for private sector and state and local government are still a little ways off. So Let's, now that we have some general introduction to accessibility, it might be good to actually focus in on the key accessibility laws, the main first topic that I was talking about. There are a lot of laws that, what we're talking about here, there are a lot of laws that focus in on civil rights. When we're not going to be touching on all of them. In fact, there are probably a lot of there are also a lot of laws that address websites to some extent or another, some directly, some not so directly. But really, the two laws that are most important for private businesses in general are ADA Title III and California's Unruh Act. So, well, even though California's Unruh Act is definitely a state law, I should also say there are a million different analogs of Title III or another disability rights law at the state level and at the state and local level. But we're not going to be focusing on those. But California's Unruh Act is different from all the others and is significant because it potentially creates a lot more room for liability. So, let's just jump right into Title III of the ADA. This was passed in 1990 by George W. Bush. In this day and age, it's kind of refreshing to see that it really did represent a bipartisan effort. When you look at the people who were involved in passing it, like Ted Kennedy and Tom Harkins on the Democrat side, as well as Bob Dole and George Bush on the Republican side, we're talking about all the leaders on both sides really coming behind this law and helping get it passed. In fact, it's been quite successful and it was extremely important. It's been described as the most sweeping civil rights law since the 1964 Civil Rights Act, which is really I think of it as the high point of the whole civil rights movement. So what does this amazing law do? Well, Title III of the ADA applies to private businesses, basically any business that affects commerce that provides goods or services to the public. When you read through the ADA, there are 12 broad categories of businesses that are potentially covered. But for our purposes, basically, there are two categories that are really important for most private businesses. Sales and rental establishments, and I think of it as service establishments. That probably covers about 80% of private businesses right there. So each of those categories is incredibly broadly sweeping. So if you're anything that even resembles a sales or rental establishment or a service establishment, then suddenly you're covered by the ADA. The ADA prohibits discrimination very broadly and protects people with disabilities. With that said, there are specific categories that are particularly relevant to us. So the law says you can't discriminate against people with disabilities, and then several paragraphs later it gets into what that really means. So one of the things that companies have to do is they have to make reasonable modifications of policies. So for instance, if a person comes to your business with a service animal like a guide dog, and you have a no pets policy, well, that no pets policy would have to be modified in order for that blind user with their service animal to take advantage of your goods and services, and so you'd have to make a modification of your policies for that service animal. The big one, though, for web accessibility is another exemption, as another provision for effective communication. And there, businesses have to ensure provide auxiliary aids and services to ensure effective communication with its customers, unless doing so would impose an undue burden on the business. Basically, that undue burden threshold is super high, so unless it really affects your year-end income at the end of the year in a significant way, you always have to provide, say, sign language interpreters if it's required for effective communication. So those are two of the key provisions that we're going to be dealing with when we're talking about web accessibility later. So what are some of the things that the ADA requires? Well, there are some obvious things. This is more when we think about the built environment accessibility. Well, what are some of the things that we have to do? Well, one of them is we have to engage in what we call readily achievable barrier removal. So there we're talking about things like providing accessible parking spaces or ramps to the front door. We also have, as I mentioned before, reasonable modifications of policies, and clearly there are a bunch of examples, but service animals is probably the one that most readily jumps out to most of us. And then there's effective communication. And effective communication, which I described a little while ago, is a very important requirement with the defenses are really, really hard to meet. I mentioned undue burden, which you basically have to show it's an impact on your financials at the end of the year. It's a really tough and a stringent requirement, but it's also a very flexible requirement. So, for instance, the examples I'm going to talk about are really relevant to some of the practical steps that we'll talk about later on in the presentation. But some examples might be, say, for instance, you're a retail store. Maybe you're a hardware store, and you sell paint. And someone comes in and they want to buy a gallon of paint. Most cases, if the customer is deaf and they communicate using sign language, it doesn't necessarily mean that you have to provide a sign language interpreter in that case. If the person's request could very easily be met just by passing notes back and forth. So if the person comes into your hardware store and just writes on a note, I need a gallon of Benjamin Moore flat white to paint my ceiling, that's not a complicated conversation, and effective communication could easily be met by passing notes. By contrast, if you go into a doctor's office and you're talking about surgery options, and it's fairly complicated, and you're talking about, what's my risk of dying, what are the side effects of the medication, all sorts of really complicated discussions like that, where you have to dig into the nuances. In that case, a sign language interpreter would almost certainly be required. In the case of websites, a website is a form of communication. So perhaps before I jump into websites, another example is, say you're a restaurant and you have printed menus. Effective communication may mean that for a blind patron, it may mean that the waiter would have to read out the contents of the menu or help the blind patron navigate through the menu to make the appropriate choices. The reason why I mentioned that example of a menu is when you think about it, a website very often really resembles a menu. It's like a printed form of communication, except it's made available instantaneously anywhere to a user. The difference is that you don't have the option of having somebody there just ready to read out the contents of your website to a visitor that comes to your website. And in fact, that's what screen readers do for users with disabilities. But you don't have that same ease of flexibility of just having someone on your staff provide that kind of services when you're talking about your website. Having said that, things like accessibility statements, which we'll talk about later, in a way provide a back door like that can go a long ways towards meeting the effective communication requirement while your website's inaccessible and while you're trying to make it accessible. So we'll talk about that in a little while. Okay, California's Unruh Act. In both traditional and web accessibility, this is the most significant state law there is. In fact, I think it's actually more important than Title III of the ADA because it has such a huge impact. California's Unruh Act is primarily it's California state law, so it affects California customers. It applies to any business activity. We'll talk about those nuances a little while in the next section when we're applying these accessibility laws to websites. And it's much easier to establish liability under California's Unruh Act, and it's also much easier to get significant damages. So let's talk a little bit about why this is such a big deal in terms of damages. As I mentioned, in many ways, businesses should be much more fearful of UNRU than they should be of the ADA. So if you have any customers in California, this is relevant to you. Now, why do I keep saying that? Well, let's see what happens if you violate Title III of the ADA. If you violate Title III of the ADA, one of two things is going to happen. Either you can get investigated by the Department of Justice, or you could face a private lawsuit. If you get investigated by the Justice Department, okay, that's a big deal. There you could be facing some significant damages. You can, the primary thing that Justice is going to do is they're going to try to fix the problem. And to do that, they will seek what they call injunctive relief. The Justice Department can also seek damages to compensate the victim of the discrimination. And they can also seek civil penalties of $75,000 for the first violation and $150,000 for every subsequent violation. Now, most of the cases that we're talking about, like the drive-by litigation for web accessibility, are private lawsuits, obviously. And there, it's much more limited. So Title III only authorizes injunctive relief and attorney's fees for private plaintiffs. That doesn't prevent private lawyers from trying to ask for damages above that, but the law actually only authorizes injunctive relief and attorney's fees. So what happens if you violate UNRU? Well, there you get either an investigation by the state AG, so the California Attorney General's office could investigate you. The federal U.S. Department of Justice never enforces state laws, so they don't get involved with UNRU Act. Or you could face a private lawsuit. And that, so far it's pretty much like ADA Title III. You get, yes, either the Attorney General or a private litigant can seek injunctive relief, but they can also seek significant damages. So here you're facing either treble damages, which is 3 times the amount of the actual the damages caused by the actual discrimination, or a minimum of $4,000 per violation, because sometimes it's hard to quantify, how much something hurt a person with a disability. So you may have heard of something called NFB versus Target, which was probably the most impactful web accessibility case out there. And in that case, they settled for $6 million. And everybody thought, oh, wow, web accessibility is amazing. Well, really, and they thought, well, maybe we could use Title III of the ADA to go and do that and get significant damages. Well, not quite. In NFB versus Target, that $6 million settlement is based almost entirely on the class of plaintiffs from California. So they broke the lawsuit down into 2 parts. One part of it dealt with their California plaintiffs, and one class was everybody else, all the other plaintiffs from around the country. For all the plaintiffs around the country, it was basically, the only thing that the attorneys could get was injunctive relief. But as for that California class, which is obviously a smaller class, that they had enough violations to get to $6 million, because they could just take the number of violations, multiply by $4,000, and really at that point you only need, what is it, 1,500 violations. So if you have 1,500 plaintiffs, you've just got $6 million. So in fact, I think that Target ended up settling for a lot less than the potential liability if they had gone to court. So with that, let's take our first break to field some questions. Still to come is addressing how these laws apply to the web and what it means for a site to be accessible, and then some practical steps on how to make this all happen. So if you have any questions, feel free to type into the chat box, and we'll be happy to answer them.
Okay, Ken, we have our first question, which is, will you be covering CVAA and FCC?
No. That's, yeah. Actually, we do have a different presentation, I think, on our Cripzone website where I talk a bit about CVAA, but no, I won't be.
Okay, I don't see any other questions.
I see Chris is typing something.
Yes, now I see him typing.
Yes, if it's another question, I'd be happy to answer it.
Why don't you keep moving, and then we can address those questions at the next stopping point.
Okay. Yeah, if you folks wouldn't mind, continue writing. Oh, there's the question.
Okay, so Chris says, I have heard rumors about working on accessibility ahead of a complaint, giving some relief of attorney fees. Have you heard anything similar?
Yeah, so attorney's fees really represent the amount of time, are supposed to represent the amount of time that the plaintiff's attorney put into filing the litigation. So if you build in accessibility ahead of time, then there are less things for the plaintiff's attorney to really dig into. We'll talk at the very fourth section about two strategies in particular that I think are really effective to just completely avoiding a web accessibility lawsuit by a private plaintiff that involve just a little bit of work on accessibility and some practical steps in terms of like putting together an accessibility statement that is really effective. So if there are, if you have any other questions that come up anytime during the presentation, feel free to put them in at the chat window while we're giving our presentation, and that way they'll just be all queued up for the next break. So Sharon, I'm going to jump into the next section. If I can find my cursor, there it is. Okay, so now that we've talked generally about some of these accessibility laws and introduced them, it's now time to try and figure out how do those laws that were really built for the bricks and mortar world, how do those real world bricks and mortar accessibility civil rights laws, how do they come to apply in the web world? It may seem like apples and oranges, right? We've got our bricks and mortar traditional world, and then we've got our digital world, and they're very separate. The way in which we do shopping, for instance, on Amazon.com is very different from the way in which customers go into, say, a Target store. So when we're taking those traditional civil rights laws and applying them to the digital world, sometimes those things aren't obvious, and it really does create some issues with the courts. And so we'll be talking about that next. Oh, darn it, I did it again. Could someone get back to the screen for me? I seem to have, whenever I hit the space bar, this happens, as opposed to hitting the front or back arrow. Okay, thanks very much. So let's talk about some of those differences between Title III and UNRUH, because these differences are relevant to trying to understand how these bricks and mortar kinds of accessibility laws apply to the web. So first, let's start with California's UNRUH Act. I mentioned before, it applies to any business activity. So even things that are very remotely related to business, as long as you could say somehow it's a business activity, it's covered. So for instance, some of the examples are condominium board meetings, well, condominiums are not places of public accommodation under Title III, so they're certainly not covered under the ADA. But a condo board meeting does affect business. It does affect commerce, so therefore it's a business activity. So even though we're talking about private residences, things like that suddenly become, subject to UNRU, whereas they wouldn't be subject to the ADA. UNRU also is, yes, as I mentioned, it's broadly worded and even covers things like condo board associations, basically anything that affects commerce. By contrast, Title III of the ADA is really limited in the regulations to apply to what we call places of public accommodation. I mentioned before that Title III's 12 categories of public accommodation are very broadly worded and are intended to be read very broadly. So basically, if you're a sales establishment, it means any kind of sales establishment. But an argument could be made that we're really talking about any kind of sales establishment as long as it has a physical place. And that extra word of place of public accommodation, is something that really hangs up the court. So we'll talk about that in a minute. And I did it again. I'm too used to hitting the space bar in order to advance my presentation. Oh, there we go. Thank you. Sorry, my last presentation, I didn't do that once, and now I just did it at least 3 times during the presentation. I apologize. So where is this place that we're talking about when we're talking about ADA Title III? Well, in a bricks and mortar context, it's obvious. If we're talking about a sales establishment, it's the store where the transaction takes place. But what's the equivalent of that store when we're talking about a website? Is it where the company is located? Is it where the servers are located? Could it be even everywhere? Could it be every place that the end users have a computer and are accessing the services? So this term place and place of public accommodation really becomes tricky when we're talking about web accessibility. But some Department of Justice, for instance, says place is irrelevant, and we'll talk about that in a minute. But other courts have said, no, not so fast. Place really is the most critical component of this. So let's talk about that. So from the Justice Department perspective, they've maintained that really place is not really relevant. They talk, and I think that it's a little bit of a shell game. I personally think this. It's a little bit of a shell game that some lawyers are playing from the appellate section on how to avoid that. So they say, well, it's really it's not intended to prevent discrimination at a place of public accommodation. It's intended to prevent discrimination of or by a place of a public accommodation. Yeah, I'm not convinced by that. Because at the end of the day, that's putting that still doesn't get around the fact that the phrase is place of public accommodation. So it's a little bit of a linguistic shell game to just try and use that argument, I believe. But nevertheless, the Justice Department's argument is set forth in 2 cases, Hooks versus OK Bridge and Rendon versus Valley Crest Production, where that position is laid out. You can get copies of the Justice Department's briefs in those cases if you're interested in how that argument goes by going to the Civil Rights Division and then drilling down into the appellate section on their website. And then there they have all of their briefs publicly available. So the Justice Department as also in the process, I should mention, the Justice Department is also in the process of coming up with new regulations affecting web accessibility. And in all likelihood, this is going to continue to ignore the focus on place. So it's not going to focus in on that. And when we look at how the circuit courts have done this, it'll become clear why that's probably the case in a moment. And while we're mentioning that the new DOJ rule that's coming out, which is quite a few years away, will almost certainly focus in on WCAG 2.0, and my prediction is going to focus in on WCAG 2.0 AA, and we'll talk about what that means in a little while. So I'm jumping ahead by saying that, but when we talk about WCAG a little bit later, that'll suddenly all make sense. Now, I mentioned before that the courts have had a devil of a time dealing with this concept of place in place of public accommodation. And for the lawyers out there, what this represents is a major split in the circuits. So for instance, some circuits take the Justice Department position that they believe that this term place in place of public accommodation really doesn't matter. So the First Circuit, for instance, Massachusetts, follows this line of reasoning. So if you wanted to sue a purely online business, I'd say Amazon, for instance, but now Amazon now has a store in Seattle. Well, okay, so if they didn't have that store, and while they are purely online, you could sue a company like that in Massachusetts. Other circuits said, no. That term place was intended to only cover activities at bricks and mortar facilities, and therefore anything that deals with the internet is off limits to the ADA. And that position has been taken by courts in the Fifth Circuit. And just recently, for instance, just within the last month, there was a district court opinion from the Southern District of Florida that followed that same reasoning. There was a case a long time ago called Access Now versus Southwest Airlines that some of you may have heard about that followed that line of reasoning. That was also out of the Southern District of Florida. And while I'm talking about that, I might as well mention that's as an aside, that there was a third case involving web accessibility in Miami. I don't know why anybody would bring a web accessibility case in Miami. But anyways, there's a third case involving web accessibility in Miami that that ended up actually going to court. And the defendants did they said, well, there's Southwest Airlines, and it says that you can't sue over a physical place of public, over an internet-based place of public accommodation. And the plaintiffs didn't think to themselves, well, maybe I need some help in getting around that argument, and rather stubbornly and arrogantly thought that they could just manage that on their own. And so they were about to create yet additional bad case law in the Southern District of Florida. When I heard about that case, I called them and I said, what are you doing? And then I called my friends at the Justice Department and said, oh my gosh, you may want to get involved in this. And a week later, the Justice Department filed a brief in the Southern District of Florida, an amicus brief, basically saying, hold your horses, we really need to change Access Now versus Southwest Airlines. So you've got two entirely polar opposite opinions that are coming out of the First Circuit up in Boston and the Fifth Circuit and the Southern District of Florida. There's a middle ground between those two extremes, and that's the approach that's taken by the Ninth Circuit. So that's basically California, Oregon, and Washington. If you file in federal district court here, I live in Seattle, the courts follow a hybrid approach that they require a nexus between the physical bricks and mortar world and the digital world. What does that mean? So for instance, the Target case is a great example of that. In that case, the plaintiffs in Target had to show that there was something on the web that connected to something that you do in a store. So they looked at things like online coupons or opportunities that you could get that combine this physical store and the virtual store. So say, for instance, you could make a purchase in a virtual store and make a return in a physical store. You had to have those kinds of connections between the bricks and mortar world and the digital world to create this so-called nexus, or a bridge between those two worlds, in order for you to be able to sue an online business. So where a plaintiff brings his case in court, this is all bringing it all in federal district court. Which federal district court they choose is really important for web accessibility under ADA Title III. And so if you happen to choose a district court in the First Circuit, you're a lot better off than if you happen to choose a district court in the Fifth Circuit. So those things definitely affect how web accessibility plays out in over the internet. So in terms of what DOJ and private litigants have been settling for, now we're getting beyond what the courts have required. In terms of what DOJ and private litigants have been settling on, is that they've been taking the consistent position that websites and mobile apps need to conform to WCAG 2.0 AA. I thought it was actually quite remarkable that they said mobile apps have to conform to WCAG 2.0 AA because mobile apps are really software and not web pages. But that is also consistent with what the new European procurement requirements say, as well as the new Section 508 requirements. So I'm not losing sleep over that. In terms of private plaintiffs, I was just recently involved in helping a plaintiff settle one of these web accessibility cases just last week, and was advising him on what the law required. And I was surprised that this private plaintiff was suing a small bank on the West Coast. It's certainly not a Citibank or a major bank like we'd like to think about in terms of the too big to fail kind of banks. This is a very small chain of banks on the West Coast, and they sued them. And in settling their case, they also demanded that they wouldn't settle their case for less than $25,000, which, given the fact that the attorney who was handling the case is probably handling a couple hundred cases just personally, there's no way that person actually worked $25,000 worth of time. But when they settled the case, that was their bottom line on settling the case. And so the important point is that you're potentially looking at like a significant amount of nuisance value when you're dealing with a private litigant. Okay, so what I've always recommended is that given the fact that private litigants and DOJ are all using WCAG 2.0 AA as their benchmark, that if you build your website to WCAG 2.0 AA, then you've created a safe harbor. You're in a safe harbor in terms of web accessibility cases. The idea is that if you've already designed your website to the level of accessibility that they would ask you to get to when at the conclusion of suing you, then there isn't any point for them to sue you. So if your web page really does, if you can get your web page up to that level of accessibility, then you've pretty much insulated yourself from a web accessibility case. But getting there is fairly difficult. So next we'll be talking about what WCAG 2.0 means and how to get there. And then the fourth step of our presentation is talking about what can you do while you're getting there to insulate yourself from liability? And there's some very simple steps there as well. But yeah, before we start jumping into that area, this would be a great point for taking some questions, because now the presentation is going to take a very different angle. And Sharon, it doesn't look like we've got any questions queued up, do we?
No, and I don't see anyone typing, so why don't you go ahead and move forward?
Okay, that's great, because I just looked at the time and we're running out of time here, so that might not be such a bad thing. Let's see. So I was almost about to hit the space bar again, Sharon, so at the very last minute I caught myself and I said, don't do that. Don't embarrass yourself a fourth time. Okay, so the focus until now has been all legal. And it hasn't been that deep of a dive. I mean, usually when I do a legal presentation on web accessibility, we really focus in on, well, other accessibility laws in addition to Title III and UNRU. And we also go much deeper. So we cover things like CVAA as well as Air Carrier Access Act and a bunch of different laws. But that's not the focus of the presentation today. Today's really more at the legal side has been more at a 30,000-foot level and at a accessibility 101 kind of presentation, but basically just the bare basics of what you need to know if you're talking about website accessibility. Now let's talk about something a little bit more technical, and here I've got to change hats. I'm a lawyer by background, and I'm not terribly technical, although I have designed a couple of websites, and I'm a Java 2 programmer. At least that's what Sun Microsystems says, as they certified me. But really, my focus is all that I don't claim to be a technical person. Now, if you are fairly technical, and I did notice some fairly technical people here on our participant list, forgive me. This is going to be a very, very, very brief skimming overview of web accessibility for people who don't know web accessibility. So if I misstate something, please don't nail me too badly. The focus is just trying to get through it at a very high level. So before I mention, there's this thing called WCAG 2.0 AA. So basically what it is it's a set of guidelines. And that set the standards for web accessibility. It was really developed by, it's developed by the W3C. They're the same people who come up with things like the HTML, the hypertext markup language requirements. So if it wasn't for W3C, for instance, we wouldn't have a common language for writing our web pages in, and the internet would be a lot more irritating and a complex place to be if it weren't for the W3C. The W3C has a bunch of working groups within it that focus in on different subject matters. So, for instance, some of them deal with, in addition to HTML, some of them deal with XML, which is Extensible Markup Language, which is kind of like a giant superset of HTML. Some of them deal with, to get into technical areas like MathML. I was a math major in college, and so if there's a way in which we can represent mathematical formulas, this is something that W3C is also interested in. So it's, one of the subgroups was the accessibility subgroup, and so here they created in a very kind of open source kind of way a set of standards. So to develop WCAG, it was basically anybody who wanted to come and join in the party could join in on the party. So as a consequence, it brought in industry and academia and government agencies and disability groups from all different kinds of disability, from the entire range of disabilities, to try and come up with a common set of guidelines that could be used for websites. So that way, it balanced all of the needs of all of these different groups. So it made sure that it provided a high level of accessibility, but not such a high level that it created an excessive burden on industry, for instance. So this was something that they said, okay, this is something we can all agree on. So it's a universal design standard. So if you design to this, you're really meeting the needs of the vast majority of people with disabilities from all different kinds of disabilities. So by designing your web page for accessibility, by designing your web page to WCAG 2.0 AA, for instance, you largely relieve yourself of the need of having to hire different disability groups to come in and look at your website and giving their opinion. Sure, that's a great idea, but a universal design standard is intended to be easily understood by just developers, for instance. So it's also an ISO standard. So that means it's an ISO standard is basically International Standards Organization, which sets standards for lots of different things. So things like radio frequency interference or fire safety standards or ISO standards run the gamut of everything. So best practices in terms of manufacturing procedures and things like that. All these things can all have standard, anything you can wrap a standard around. When you develop it to the point that it becomes an ISO standard, then it really becomes an international benchmark that people should be following. So standards geeks love the fact that it's now an ISO standard because suddenly it's that much more respectable. And as I mentioned, this is a yardstick that the Department of Justice and all private litigants are using in their recent settlement agreements. Specifically, they're looking at the AA level. And we'll talk about what that means in just a little bit. Okay, so you may be asking yourself, we've heard about a lot of different standards. Why WCAG 2.0 and not AA and not some others? So, for instance, we had before a lot of different standards. We had WCAG 1.0. We had Section 508 requirements, Canada's look and feel requirements. The reason for WCAG 2.0 is because this is the thing that WCAG 2.0, and specifically the AA level, is the level that everybody's gravitating towards. It's also part of the new Section 508 standards that just came out for the federal agencies. So also state and local governments are also increasingly looking at WCAG 2.0 AA as their yardstick for accessibility. So it really is, it not just represents a safe harbor, but it really does represent where the future is going towards. Okay, so I mentioned this thing called WCAG 2.0 AA. What's a AA all about? There are 3 levels of conformance within WCAG. It's broken down into, I'll talk about this in the next slide, but it's broken down into different levels of granularity. And basically, there are a whole bunch of these things called success criteria. And the success criteria are categorized as either A, which basically means so fundamentally important you absolutely have to do this if you even care anything about accessibility. AA, which is next higher level up, which is basically, a robust, very usable form of accessibility. And then there's AAA, which is kind of a best practice for accessibility, but even the W3C admits that it's impractical to develop a website entirely to AAA and to use that as your benchmark. So what you really want to be focusing on is the A and AA levels. So that comes out to about 38 different success criteria. So yes, as I just mentioned, the structure of WCAG is broken down into different levels of granularity. At the top, there's the principles. There are only 4 principles that everybody remembers as the POUR principles, P-O-U-R. That's perceivable, operable, usable, and robust. So it sounds like incredibly broad categories, and quite frankly, I never use them because they're just at such a vague, abstract level of usefulness. Below that are the guidelines, where they actually try to put some meat on the bones in terms of what those things mean. But even at the guideline level, WCAG 2.0 still isn't particularly useful because it doesn't tell you specifically what you've got to do. Within each of the guidelines, there are a bunch of success criteria, and that's the level that is where we really want to be focused. Then there's the techniques underneath the success criteria, and there it gets a little bit in the weeds. And so if you're implementing a particular success criteria, it's useful to look at the techniques. But if we're trying to figure out if we want to answer the question, what is it that we've got to do, look at the success criteria level of WCAG 2.0, and there look for the ones that say A or AA. So that in itself can be kind of daunting. That sounds simple until you actually look at it. If you're new to web accessibility, this can feel pretty overwhelming. On the screen here, I've got all of the 38 WCAG 2.0 A and AA success criteria. and just the titles, because if I actually put the text in, it would just, I'll just demonstrate on the next slide. It can get a little overwhelming. Some of them may be obvious, like you want to make sure that if you have web content that flashes, that it flashes 3 times or less per second, and that's 2.3.1. But some of the others is things like, well, gosh, I'm a newcomer to this. What's keyboard mean? Well, basically, we want keyboard access, but you wouldn't know that from just looking at the title. So when you look at all 38 of the success criteria on one screen, it does look really overwhelming and confusing. Then when you drill down to each one of the success criteria, even that can seem pretty complex if you're a newcomer to this. So on the screen I have success criteria 1.1.1, which is the most basic and probably most important of all the WCAG requirements. This is the one that gets to things like text alternatives. So if you've got an image on your web page, you have to provide, obviously, an alt attribute for that image, so a person who uses a screen reader can have that content read out to them. And we'll talk about some of those more practical examples later. But looking at the actual text of 1.1.1, it can seem a little, well, as the title says, complex and arcane. And it really is. It doesn't tell you exactly, what it is that you've got to do. The techniques that support WCAG, that success criteria 1.1.1, get into things like, okay, oh yeah, you put an alt attribute on an image tag, but that isn't obvious that that's the way you do it from just reading the success criteria. So this really is an area that takes some specialization to work on. So not just every web developer can just pick up a copy of WCAG 2.0 and just do it. So you really do want to make sure that your the people that you hire know what they're doing in terms of web accessibility. So to understand, like, even the most basic one, 1.1.1, it might be useful to talk about, like, well, what does it mean to add an alt attribute on an image, and how is this relevant? Well, to answer that, you have to first get back to, what it is, how it is that people with disabilities access technology. So say you're blind and you're using a computer and you're going to a website. Because you can't see the things that are actually on the screen, you're probably going to rely on technologies like screen readers. And screen readers, just as the name suggests, read the screen. They read it from top to bottom, left to right, and typically, unless you change the reading order, and there are ways in which you can do that. But typically it's top to bottom, left to right. And it reads it serially. So that means that there are challenges. So most of us, when we think about reading, we think about it just as being exactly that, top to bottom, left to right. Well, if you're in Asia, I suppose it's top to bottom, right to left. But anyways, we still take in information in a serial fashion most of the time. There are some times where we don't. And we'll talk about some of those challenges. And it's where you don't take in information just purely in a serial form that a lot of the challenges come up for web accessibility. But before we get to those nuances, let's think about this very basic example, alt attributes on images. So the most obvious challenge for a person using a screen reader that's reading text from the screen is what about content that isn't text? So here on the screen, I've got a picture of the American flag. But it's not just pictures of things like this that create the challenges. Less obvious examples are pictures of text. So for instance, here I've got a picture of the IAAP logo. That was created by a graphics design artist, and it looks like text, but actually it isn't text. It can't be rendered back into ASCII code. It's actually a picture. It's a picture of letters, but it's not actual text itself. So how do you make these things accessible? Well, you basically add, as I mentioned, an alt attribute. So here I've got a code sample. So if you're developing a web page, the way in which you put an image, say a flag, into a web page is you use this tag. And tags are these things between these angle brackets. And so if you say tag image, or img, and the source equals flag.gif, what it's saying is on the screen at this location, put a picture. And what picture is that? Flag.gif. Okay, so great. A picture of the American flag suddenly shows up on your screen. If you want to make that accessible, the only thing you have to do is within that same image tag is to put in alt equals and a description of what it is that it is a picture of. So flag.gif doesn't tell the user that much. It could be any flag, right? It doesn't even have to be a flag. It could be anything that you just happen to name. Flag. It just has to be some file you name flag.gif. Not particularly useful. Much more descriptive is something that says American flag, because that's really the intention of what you wanted to, what it is that you've got up there. And so alt equals American flag is all that you'd have to put in order to make that image suddenly accessible to a screen reader. Another huge challenge for screen readers are forms. So the kind of forms that we use whenever we do e-commerce create big challenges. So here on the screen I've got what is a typical form, a field that asks for first name. Now if you look at that and you don't know that much about accessibility, you'd think, well, what's the big deal with that? The form field is right next to the thing that says first name. The problem is that while that may be visually obvious because of the proximity of first name to that text field, it isn't obvious to a screen reader. And that's particularly true because screen reader users very often will just jump from the fields to the next field. And another complication is that to make things beautiful and laid out, that sometimes they'll put the web designer will put this all in a giant table so that everything lines up nicely, and then suddenly they're talking about different cells, and the connection between that field and the label associated with that field isn't obvious. So also here on the screen I have the code sample. So typically it would be something like first name colon and then an input field. To make this accessible, you use something called a label tag. And basically what this does is it identifies something as a label. So here in this example, first name is contained, if you will, suddenly between an opening and closing label tag. So there's the label, there's the first part that opens it and it says for and it says F_name. And then it closes it after the whole text first name. And then within the input field, we add something called an ID field. And the identity of that ID field needs to match the label. So potentially you could put that label, first name, at the complete opposite end of the page, as long as the ID of that, as long as it matches the ID attribute on the actual input field. Whenever a user hits that input field, it's going to read out, the screen reader is going to read out the thing that's contained in the label tag with the same ID. So even though it could be completely opposite end of the web page, when they hit that form field, it'll still say first name. And that's the simple trick for making forms accessible. And if you just did the images and the form fields, I think it'd dramatically improve accessibility in your web page. Another area where accessibility breaks down are tables. Now remember I mentioned that screen readers read things serially. That becomes a real challenge when we're talking about tables. So when we think about like a big data table, say we're looking at statistical information from Bureau of Labor Statistics, you have these huge tables. You can get easily caught in the middle of a table where it's not visually obvious it's visually obvious what the data in one particular cell represents, because we look up at the top of the column and we look to the beginning of the row to figure out like what it is that it's associated with. So here, for instance, on the screen, I've got a potential entry from a multiplication table. 3 times 2 is 6, and that's basically what the table represents. To a screen reader user, that can be a real challenge. Unless you do some simple technique like saying, oh, that row where that number 2 is and the column where that number 3 is, those are both header cells. So if you change them from table data cells to table header cells, then that association can be made. So simple little tricks, but yeah, vitally important for accessibility. You might, oh gosh darn it, I did it again, Sharon. I hit the space bar again. Thank you. Okay, I think that's the 5th time I've done that. You can tell what my default way of handling advancing PowerPoint slides is when I'm just doing it in a live audience. Everything I've said until now has really dealt with screen readers. That might give you the impression that it's only if we're talking about visual accessibility. That's obviously not true. Things like captioning are also critically important and a critical element of WCAG. And I'm falling behind on schedule. So let's talk about, let's take a break for questions real quick. And then I'm going to buzz into the actual summary of steps that I think are critical for avoiding website liability.
Okay, Ken, we have a question from Chris saying, my perception is that transactional sites are at a higher risk of complaints than content sites. Has that been your experience?
Yeah, absolutely. E-commerce sites, banking sites, sites that require user interaction, for some reason are top of the list, which makes me actually wonder, and that raises a kind of a related but interesting point. Some of these plaintiffs' attorneys are bringing literally hundreds, sometimes even thousands of cases, and we probably know who some of those attorneys are. Some of those law firms, they've almost become household names within the world of web accessibility. In order to bring that many lawsuits, they have nominal plaintiffs but in general, they're not the ones that are really the people that are harmed. For instance, that bank that I mentioned before, they found out because the plaintiff's attorney got sloppy that that same plaintiff was suing another bank just down the street. That's also a small chain of banks on the West Coast. The plaintiff lives on the East Coast. It's highly unlikely that they have a blind plaintiff who was actually interested in opening an account at either of those two banks because, again, they're an East Coast company, East Coast law firm with an East Coast plaintiff suing a California bank and demanding damages. The way in which a lot of these law firms are obviously going about finding these potential defendants to sue is by using automated technologies. And so they're looking for obvious things. So I'll talk about this in a little while, but they're using automated technology to scan websites for obvious violations like missing form labels, missing alt attributes on images. Those are probably the two big ones. And so if you want to avoid those problems, if you want to avoid a plaintiff suing you, if you eliminate those two accessibility issues, then you may not get caught by that automated testing tool. And in that case, you might just completely fly under the radar, even if you're inaccessible. I'm not saying you want an inaccessible website, but just by doing those things that fail automated testing in an obvious way, you may very well avoid liability. Okay, so let me buzz through the last section of the presentation because that's probably what a lot of people are really waiting for. But we weren't able to get to until now because we really needed this background. So now we know something about website accessibility and some civil rights laws. How do you apply this to your website? This isn't something that I can really dive into in super deep, but let's do it anyway. Let's hit the highlights anyways. I think there are 4 key components to avoiding liability and ultimately achieving accessibility. And I apologize for this because they're not in a perfect order on this slide. If I had a chance to redo it all again, I would change the order of some of these elements. But let's talk about them. First and foremost, assessing and remediating the content of your existing site. And here we're talking about things like taking your key transaction paths. Like, for instance, the transactional sites, say you're a bank, the key things that people come to your site for. So, for instance, logging into your account, checking your checking account balance, transferring money to you from your savings to your checking account, paying a bill. Those key activities that people always use and are the bread and butter of your site, those things should be checked, and they should be checked hard. You should be using real-world testers, not relying on automated testing technology for that stuff, to really nail down and make sure that that's perfect and conforms to WCAG 2.0 AA. Another example, e-commerce systems. So the shopping cart experience, searching for an item, adding it to your shopping cart, going through the checkout procedure. That should be absolutely accessible if you're an e-commerce site. Second, obviously, is training and developing resources for your web developers. That's to make sure that your future content is accessible. Follow-up testing, and that includes manual and automated testing. That's also a critical component towards web accessibility and avoiding lawsuits. But the most important thing is a non-technological answer, and that's developing a really good accessibility statement. And I'll tell you what goes in it and why you want to do it in just a little while. I'm going to go back to that slide again. So yeah, again, I apologize. If I were to think about the two things that I would do first, it would probably be the last two elements. So in particular, there is an automated testing component to this. I'll talk about this towards the end, but just in case I run out of time. Developing a really strong accessibility statement and testing your web page using automated technologies for 4 basic, simple, objective things, not all WCAG 2.0, but 4 basic things that every plaintiff out there is probably looking for, are probably the most important thing. And we have a white paper that's available that walks you through what those 4 things you want to be testing for. If you test your website for those 4 basic things, correct those 4 basic things, and have a strong accessibility statement, I really think that your chances of a web accessibility lawsuit just drop by 75%. The other elements of, probably the third most important thing is the thing that's listed first, which is taking care of those key transaction paths. And then lastly, probably the 4th most important thing is the second bullet here, which is the training and the resources for the web developers. Again, I apologize for the order of these bullets. It's not, if I had a chance to do it over again, I would. So let me quickly buzz through some of these concepts. So assessing your web content and remediating it. You want to make sure to hire somebody to test those key transaction paths that really knows what they're doing. You need somebody who understands WCAG 2.0 AA like the back of their hand. They should be a company that does this all day long. And there are a bunch out there. Cryptzone's just one of them. But you go to an accessibility conference, it'll be obvious who they are. If you do, hopefully come by our booth. But anyways, there are a bunch of companies that work in this area, and they all do it very well. Sure, there are some that don't, but the big players, we all do it very well, and we all do it pretty much the same way. And you want to make sure that you want to test your key transaction paths really well. You don't want to rely on automated testing technologies alone for dealing with those key transaction paths. If you're an e-commerce system, you don't want to rely entirely upon using an automated testing tool for testing that, because your shopping cart experience, that is really the bread and butter of your site. You want to make sure that that's tested using manual testing. So an actual human tester and one who's really experienced in web accessibility. Okay, training is an obvious part of every accessibility program. You know, but really, I mean, I think that it's most important for web accessibility training is most important when we're talking about companies that are developing their own web content. You know, companies run the gamut in how much they refresh their sites and who does it. If you have content management systems, for instance, it's absolutely critical that the people who are adding content to your site, which they're doing every day, that those people understand how to make sure that the new content that's going in is accessible. Other companies that have relatively static web pages but are refreshed, say, every couple of years, for them, the training resources really need to go on the development side for their developers, but often those companies use outside developers. So it's rather a question of making sure that the outside developers are really well trained in accessibility. If you are going to handle WCAG accessibility and you want to do it for your entire organization, I recommend that you start one guideline at a time. A couple of years ago, there was a presentation at CSUN, which is probably the biggest web accessibility conference in the world, that were 4 different or 3 different, I forgot what the number is, major universities all presented the same year on how to achieve website accessibility. And they claimed, well, you know what, we pretty much cracked this nut. And they independently went off and gave that presentation. It was interesting that they all happened to be our clients, which was great for our marketing people, but much more important was the strategy that they used, because really the strategy they could use, it's not reliant on our technology. It's just something that we suggested that they do, and they ran with it, and they said, wow, this works great. The idea was that if you're an organization that has a huge number of website pages, it's most practical if you don't try and tackle WCAG 2.0 AA all at once, that instead you take it one guideline at a time. I don't say take it one success criteria at a time. Remember, there's that breakdown in terms of the structure of WCAG. That's one area where handling it one guideline at a time makes a lot of sense, because one guideline will encompass a bunch of related success criteria. So, and you also need training that's focused on different levels of an organization. So when we give training, and I loathe training personally, but I do it, we train at focusing on business owners separate from web designers, separate from web developers. A web developer needs to know things like WCAG 2.0 AA. A web designer needs to know things like, how do I make sure that my wireframes maximize accessibility, so when I give those wireframes over to the developer, it'll make it much easier for them to make the web content accessible. The business owner needs to be trained on all the legal nuances that I've talked about throughout the presentations to make sure that they understand fully why it is that they have to make sure that they incorporate accessibility. So, let's mention third element. I'm going to vary this a little bit, but it's yes, it's important that if you add new content, that it regularly gets tested for accessibility. Usually follow-up assessments are, in my experience, roughly half the cost of an initial assessment if you have it done by the same people, because they know what they're looking at. Here it's maybe cost-effective to leverage automated technologies. Okay, so really what I wanted to talk about here was the automated technologies. Again, you really want to focus on that if you're thinking about avoiding lawsuits from the very get-go. I mentioned before, there are 4 key things that you should be looking for, and there's a white paper that we have that's separately available that talks about that. So now the most important thing for avoiding lawsuits in the first place. Remember when I talked about earlier in the presentation this concept of effective communication? An accessibility statement goes a long way towards reducing liability because it effectively provides a backdoor into your content. So an accessibility statement should lay out your plans for achieving website accessibility. So you can say in there, for instance, that your goal is WCAG 2.0 level AA, and here are the things that we're thinking about to get there. It should also ideally set your milestones to say that you're serious about achieving website liability. But the most important thing that an accessibility statement should do is it should provide a backdoor into providing access to the content. And so it may be a telephone number that's that you're actually going to answer that will walk people with disabilities if they need help through your website. So if you're an e-commerce site, helping a customer actually get the thing that they're after. You want to put that every place. You want to put it on your footer of your homepage and every place that a user interacts with your website. For those of you who already have things like privacy statements, to conform to the California Online Privacy Protection Act, or OPA, the law requires that it be on your homepage and every place you've got a form field. It also makes sense to also provide an accessibility statement at provide a link to your accessibility statement at those same locations. And I hit the space bar a sixth time. Sharon, could you bring back the screen? Yes, and I really should put a Post-it note on my space bar, but unfortunately I don't have
And Ken, I do want to note we are out of time, so I'm going to ask you to quickly go through those last slides because we do need to wrap up.
Okay, thanks. Yeah. Okay, sorry about that, folks. And make sure you really follow your accessibility statement. If you do all that, I really do believe you're talking about significantly reducing your liability. So we haven't talked about mobile apps, but obviously those have to follow WCAG 2.0. We didn't talk about PDFs also in this presentation. Again, those can be difficult to make accessible, but you really do want to make sure that those are accessible as well. Won't dealing with vendors and contractors, but you can get a copy of the presentation afterwards. You want to make sure that whoever does it has done it before, basically. If you actually do get sued, make sure you have outside counsel, obviously. Please, please, please do that. Don't call me first. And develop an accessibility plan. That's the first thing I recommend whenever outside counsel calls me. And so you'll want to make sure that your outside counsel is thinking about doing the same thing. Now, I mentioned before there are a couple key resources that are available. And I am going to spend a couple seconds talking about this one. This, even though we're running over. A couple of years ago, we went through every complaint and settlement agreement that was publicly available and looked at what actually got the organization into trouble. And it came down to 4 basic things: inaccessible forms, images, data tables, and image maps. But if you want the analysis that goes along with that, you'll want a copy of that white paper. And the other thing is, we've talked about accessibility laws. We also have a recorded presentation on website liability under U.S. accessibility laws that dives into all the different laws, and it's purely a legal presentation. It doesn't cover all the WCAG stuff. So if you're interested in this from a legal perspective, I urge you to take a look at that presentation. So thanks very much, and I apologize for running over. If there are any questions, I'm happy to stick around for to answer any additional questions.
Ken, thank you so much. You did a great job covering a lot of information in this hour and a half, and clearly this is a topic that we could spend all day talking about. So I'm going to go ahead and put up some information, and if someone does have additional questions, go ahead, type them into the chat. If we have a minute or so to address them, we will try to do that. So I want to thank Ken for all the effort he put into putting this together for us. I want to thank our captionist, Carol Lynn from TCS Interpreting, for doing a great job keeping up with all this information. And I just want to show all of you, I've put up a slide that has a link to our feedback survey. We really appreciate your filling out this feedback survey. Give us feedback on today's webinar. We really pay attention to your feedback. We'll send out within a day or two an email that will provide you also with this link and also with a link to the recording of today's presentation. So that will go out to everyone who's registered for today's webinar. So please do take the time and fill out the survey. And I also just want to let everyone know that we have some great upcoming webinars. So on February 15th, we have a webinar on using the W3C ARIA Authoring Practices Guide 1.1 to build accessible web resources. And on Thursday, March 23rd, we have Section 508 refresh, understanding the new requirements, and other great webinars. We have webinars scheduled out through June and more coming very soon for the rest of the year. So please go to our website. The IAAP website is accessibilityassociation.org, and just check out what we have coming down the pike. So I don't see any more questions. So again, I want to thank everybody. Thank you for joining us today. And again, thank Ken and our captionist for this great webinar. So with that, to log out of the webinar today, all you need to do is just close your Adobe Connect or close your browser. And if you're on the phone, hang up the phone, and you'll be out of today's webinar. So thank you, everybody. Hope to see you at a future webinar. Have a great day.